Okay. Good morning, everyone. We had some discussions off the record before we began, but we have started the recording, so we're going to begin this hearing now. This hearing before the Connecticut Office of Health Strategy is identified by docket number 21-32486 pursuant to Connecticut General Statute, Section 19A-653. The petitioner in this matter, the Connecticut Office of Health Strategy, issued a notice of civil penalty in the amount of $394,000 to the respondent, Johnson Memorial Hospital, relating to its alleged failure to seek certificate of need approval under the Connecticut General Statute, Section 19A-638A, for the termination of services, specifically inpatient obstetric services or labor and delivery services. Thereafter, the respondent requested a hearing to contest the imposition of the civil penalty, and OHS issued a notice of hearing for today's date. Today is November 16th, 2022. My name is Daniel Chuka. Executive Director Kimberly Martone designated me to be the hearing officer, and I will be issuing the proposed final decision in this matter. Also present on behalf of the agency is Roy Wong. He's an associate research analyst. He will be available to assist me today if needed. Public Act number 21-2, as amended by Public Act number 22-3, authorizes an agency to hold a hearing by means of electronic equipment. In accordance with the Public Acts, any person who participates orally in an electronic meeting shall make a good faith effort to state his or her name and title at the outset of each occasion that such person participates orally during an uninterrupted dialogue or series of questions and answers. I ask that all members of the public mute their device that they're using to access the hearing and silence any additional devices that are around them. This hearing is held pursuant to 19A-653 and will be conducted under the provisions of Chapter 54 of the General Statutes. That's the Uniform Administrative Procedure Act. The certificate of need process is a regulatory process, and as such, the highest level of respect will be accorded to the petitioner, the respondent, and OHS staff. Our priority is the integrity and transparency of the process. Accordingly, decorum must be maintained by all present during these proceedings. This hearing is being transcribed and recorded, and the video will also be made available on the OHS website and its YouTube account. All documents related to this hearing that have been or will be submitted to the Office of Health Strategy are available for your review through the electronic certificate of need portal, which is accessible on OHS's CON webpage. As indicated in the agenda, although the hearing is open to the public, only the petitioner, respondent, OHS, and their respective representatives will be permitted to make comments. Accordingly, the chat feature in this Zoom call has been disabled. As this hearing is being held virtually, we ask that anyone speaking, to the extent possible, enable the use of the video camera on their laptops or other devices when speaking during the proceedings. In addition, as I mentioned earlier, anyone who is not speaking should make their best efforts to mute their electronic devices. And lastly, as Zoom notified you in the course of entering this meeting, you are appearing on camera, and so if you are not consenting to being filmed, you should revoke your consent and drop off the call at this time. The CON portal contains the table of record in this case. As of yesterday afternoon, when I looked at it around 6 p.m., it looked like exhibits had been identified from A through Q. I'm just going to ask that petitioner's counsel identify herself, petitioner being the Office of Health Strategy.
Yes, good morning. Good morning, all. My name is Laura Manzione, and I represent the Office of Health Strategy.
And counsel for respondent, Johnson Memorial Hospital, can you please identify yourself for the record, please?
Good morning, Your Honor. My name is David DeBasio of Hinckley Allen on behalf of Johnson Memorial Hospital, Inc.
Thank you. So looking at the exhibits A through Q, do either of you have any objections to any of those? Again, those are the documents that were uploaded to, or that were in the table of record. Starting first with Ms. Manzione, do you have any objections to any of those?
No, I don't have any objections to them per se. I did notice that at different points in the timeline of this proceeding that they had been inaccurately named. And when that came to my attention, I tried to communicate with OHS staff that that was the case. So I hope that they are all now accurately titled. And I agree that with Attorney DeBasio that yes, there is that one error in the end. It's called respondent, but it's called petitioner, but it should be respondent. So that is one point. The other point is, as my opposing counsel remarked earlier, he and I have spent a bit of time coming up with a list of agreed upon stipulated facts. And I don't think either one of us had the ability to upload it last night, but I think it is complete. And I think it would serve everyone if we could be allowed to upload that to the portal. And so it could become part of the record at some point this morning.
Okay. It doesn't need to be during the hearing. It can be after. I'm not going to be able to read through it right now anyway, unless one of you wants to bring it up on the video. And the exhibit that you were referencing as being inaccurately labeled in the table of record was Exhibit J. That's respondents pre-filed, correct?
Yes.
That's correct, Your Honor.
Thank you. So we will correct that in the final table of record after the hearing has concluded. And also, I'm not sure if it's in the table of record or in the agenda or both, but as Attorney DeBasio indicated earlier when we were off the record, the petitioner in this case is Johnson Memorial Hospital, Inc., correct?
That's
No.
the respondent, Your Honor.
I'm sorry, respondent.
OHS is the petitioner.
Yes, sorry.
That's okay. That's okay.
Johnson Memorial Hospital, Inc. is the respondent, correct?
That's
Not
correct. Your Honor.
Trinity Health of New England.
That's correct, Your Honor.
Okay, thank you.
And I believe counsel will agree with me. The penalty's been levied against Johnson Memorial Hospital, Inc.
Okay, thank you.
That was the intention.
Yeah. The only other thing I would add, Your Honor, is that I have no problem with exhibits A through P, but the table of record I got doesn't have an exhibit Q. And the one I saw on the portal when I checked today doesn't have an exhibit Q. So
Okay.
I'm probably prepared to stipulate to exhibit Q, but until I actually know what it is, I can't go ahead and, so I'm prepared to stipulate to A through P.
Let me,
I think
Hold on.
Exhibit Q is the actual table of record.
Oh. To the extent exhibit Q is the table of record, I stipulate to that as well.
And there's also an Exhibit R, which is the OHS's exhibit list of 2 documents that I showed to you before, Attorney DeBasio. It's Exhibit number 1, which we think is actually the same as Johnson's exhibit letter I. And exhibit number 2 is the only new document that hasn't been introduced before today. And I know you have not had a chance to respond to it. I don't know what your opinion is, if you are going to accept it, but that is exhibit letter R, according to the table of record.
all right, so that there are no issues with A through Q, Q being the table of record that does not have letter Q in it. As far as R goes, that is, from what I can tell, as you just indicated, Attorney Manzione, the filing that you made last night with the 2 exhibits. Attorney DeBasio, do you have any objection to either of those?
I don't have an objection to exhibit 1. I would like to conduct a brief voir dire about exhibit 2 because I just wanted to confirm how this information was circulated before I stipulate to it. So I imagine we're going to get to that point, but this is the first time I've seen it. It wasn't available on OHS's website, so I'd just like to do a brief voir dire of Mr. Lazarus about how this document was published and circulated.
Okay. All
Yeah, I
right,
expected that was,
we can get to that later on. I'm not going to do the voir dire right now, but after after Mr. Lazarus presents his testimony and you're cross-examining him, you're free to ask those questions.
Absolutely understand. I just also mentioned it because Attorney Manzione may be able to, I would guess, could also address it as soon as she introduces Mr. Lazarus's testimony, and then I probably wouldn't have any objection.
Okay. If that works for you, Attorney Manzione, feel free to do that as well. I'm okay with either one.
sounds good.
So that's are there any other documents or exhibits that either party wishes to put into the record at this time? Oh, so I guess the stipulated facts would be S, correct? Okay.
Yes.
Yes. And that is a joint stipulation, so we both consent to that. I shouldn't say we both. I consent to that becoming part of the record once it's filed.
So do I. I also consent, and it's a joint stipulation.
Okay. All right, so I don't know why I would need to look at these particular documents, but I'm going to take administrative notice of them anyway. It's the statewide healthcare facilities and services plan, the facilities and services inventory, OHS acute care hospital discharge database, hospital reporting system, HRS, financial and utilization data, and all payer claims database claims data. Also, I should have mentioned all of those exhibits are entered as full exhibits, with the exception being letter R, which we will get to. And then that will likely, it sounds like it may also be a full exhibit as well.
And also OHS number 2, until we establish foundation for it. It should not be entered as a full exhibit yet.
Yeah, that's part of our, it's confusing the way. Yeah.
Sorry, I was thinking, yeah, you're right. It is confusing.
I'm also going to be taking administrative notice of some dockets that I am aware of that I think may be relevant to the proceeding. One of which is actually the remainder of this docket, which is 21-32486. Because there are, from what I could tell, documents related to a determination, an investigation of some kind, a civil penalty, and also the certificate of need application. I think a lot of those, if not all of those documents, are already in the exhibits that the two of you have stipulated to. But I could be wrong.
There are 2 that are in the portal that are not part of the stipulated exhibits and testimony. There is an anonymous letter that was sent to OHS that is not part of our record or presentation for this hearing at this time. And there was another letter from ATF, I believe it was, asking for the investigation itself that Attorney Manzione and I have not made an exhibit or part of this particular record.
Thank you. I'm going to run through the rest of these dockets now. One of which is docket number 15-31998. That is Milford Hospital's termination of OB services. Docket number 15-32014, which is Sharon Hospital's termination of sleep center. Docket number 04-30297, which is Lawrence and Memorial's suspension of angioplasty. Docket number 04-30272, which is John Dempsey Hospital's suspension of its bone marrow transplant program. Docket number 03-23013, which is Yale New Haven Hospital's suspension of its liver transplant program. And then there are 4 civil penalty dockets from between 2012 and 2014. One is 12-31797. That's the civil penalty issued regarding Greenwich Hospital's termination of its dental clinic. Docket number 14-31905, which is the civil penalty issued regarding Yale New Haven Hospital's acquisition of 2 pieces of imaging equipment. Docket number 14-31943, civil penalty issued regarding Essent Healthcare of Connecticut. That's Sharon Hospital's termination of its intensive outpatient psychiatric program. And then finally, 14-31953, civil penalty issued regarding Hartford Hospital's acquisition of a piece of imaging technology. I may also take administrative notice of other dockets as we go through if they're presented by either party. And I may also look at other decisions that may come up as I'm reviewing the matter.
Hearing Officer Chuka, I would ask that the tribunal take administrative notice of the 2 currently pending civil penalty matters that are, I have the docket numbers. I'm not sure what the year is, but the first one is 32516, which is Rockville General Hospital, the termination of surgical services. And the other one is 32517, which is Wyndham Hospital, termination of services, labor and delivery.
Okay. I will take notice of those. Thank you. So with that, we will proceed in the order established by today's agenda. Are there any other housekeeping matters or procedural issues that we need to address before we start? Hearing none, I will move on. Is there an opening statement from OHS, Attorney Manzione?
Yes.
Okay.
Yes.
So you can proceed whenever you're ready.
Sure. I'd just like to clarify. So will it be, will the process be opening statement of the respondent, or will it be opening statement and then I go to my witness? I don't have a preference. I'm just looking to plan.
I had planned it, and the agenda indicates it'll be your opening statement and then your evidence, and then it'll be, cross-exam and redirect on your witness, and then we will turn to the respondent's opening statement, his client's evidence, and cross-exam and redirect, and then your closing argument, Ms. Manzione, and then the respondent's closing argument.
Okay,
So you can proceed whenever you're ready, and then we will take some time to introduce your witness and have him go under oath.
okay, sounds good. Thank you. Good morning. Good morning. My name is Lara Manzione. I am representing the petitioner, the Office of Health Strategy. Today, we are here to determine whether the Office of Health Strategy properly imposed a civil penalty on Johnson Memorial Hospital. Specifically, the question is whether Johnson Memorial Hospital willfully failed to seek a certificate of need, or CON, before terminating its labor and delivery services. The parties to this hearing agree on most of the facts in this case. There was a terrible pandemic of COVID-19 that came to the United States in early 2020. The governor of Connecticut issued a series of executive orders to try to stem the spread of this unknown virus. The governor also granted unusual authority to healthcare regulators to assist in mobilizing resources to fight the pandemic quickly and efficiently. The evidence will show that one of these orders, Executive Order 7B, gave the executive director of the Office of Health Strategy authority to waive certificate of need requirements starting on March 14th, 2020. The Office of Health Strategy started a notification and waiver program that many hospitals and other institutions took advantage of to bypass the usually lengthy CON requirements in order to help in the battle against COVID-19. Johnson Memorial Hospital utilized this special waiver program to stop providing labor and delivery services during the early part of the pandemic. However, when OHS's authority to operate the waiver program ended, the hospital did not reinstitute the labor and delivery services, nor did it seek a CON to officially terminate the services. This is where the parties to this matter disagree. What happens if a hospital stops providing an inpatient service without a certificate of need? The evidence will show that typically, if a hospital wants to cease providing an inpatient service, it must file a CON application with the Office of Health Strategy before stopping that service, so the regulator can evaluate whether the hospital should be allowed to do so. If a hospital terminates an inpatient service without a CON, it is a violation of law and the hospital is subject to a civil penalty. And that's why we're here today. There are two related applicable laws at issue. The first is Connecticut General Statute Section 19A-638A5. This law requires that a CON, certificate of need, be granted in order to terminate inpatient services offered by a hospital. The other law is Connecticut General Statute Section 19A-653. It states that if a healthcare facility or institution that is required to file a CON under Section 19A-638 willfully fails to seek CON approval for any of the activities in 19A-638, they shall be subject to a civil penalty of up to $1,000 per day for each day such healthcare facility or institution conducts any of the described activities without certificate of need approval as required by Section 19A-638. The evidence presented today will show that Johnson Memorial Hospital violated these laws. The hospital knew that they violated the laws and therefore acted willfully. Today, Johnson and Memorial Hospital will offer three reasons why they are not in violation of the law. First, the hospital will say that because they were in frequent communication with OHS staff and repeatedly said that they were intending to only suspend L&D services, that gave the hospital approval to keep the L&D services suspended. Second, Johnson Memorial Hospital will say it had to suspend the L&D services because it could not find enough qualified providers to offer 24/7 coverage for those services. The hospital will provide evidence that they did everything they could to try to recruit and hire more staff, but failed. And thirdly, Johnson Memorial Hospital will say that it had a good faith misunderstanding of either the facts of the situation or the applicable law. In terms of the facts, the hospital will say that it believed that the labor market would improve and that one day soon they would be able to hire enough qualified people to lift the suspension on providing labor and delivery services. Alternatively, the hospital will show that it had a good faith misunderstanding that a CON was not required to stop providing L&D services because it never intended to terminate L&D services, but only ever intended to suspend them temporarily. The Office of Health Strategy will show through documents and testimony that none of these reasons will protect Johnson Memorial Hospital from receiving a civil penalty. As I mentioned earlier, at the beginning of the COVID-19 pandemic, special rules were enacted that allowed hospitals, including Johnson Memorial Hospital, to stop providing inpatient services without a CON. Therefore, JMH's suspension of labor and delivery services in October of 2020 under the notification and waiver program was entirely appropriate and legal. However, the notification and waiver program made clear that once public health conditions returned to normal and the executive orders were lifted, that CONs would once again be required for activities that hadn't needed them during the pandemic. To reiterate, the evidence will show that Johnson Memorial Hospital suspended its labor and delivery services on October 14th, 2020, and that labor and delivery services have not been restarted since that date, since October 14th, 2020. The evidence will show that the governor caused certain authorizations to expire in the spring of 2021 pursuant to Executive Order 12B. This executive order caused OHS's authority to waive CON requirements to expire. The authority officially expired at 11:59 p.m. on May 28th, 2021. Therefore, as of May 29th, 2021, all the organizations OHS regulated were expected to return to business as usual. The evidence will show that Johnson Memorial Hospital did not resume labor and delivery services on that date of May 29th, 2021, as it should have, nor did Johnson Memorial Hospital resume labor and delivery services after OHS issued a guidance document on October 22nd, 2021, clarifying that all hospitals that had received a CON waiver should be back to pre-waiver conditions. Continued suspension would constitute a violation of CON statutes and regulations. The evidence will further show that even though Johnson Memorial Hospital knew that the governor revoked the executive orders granting OHS extraordinary authority and that they should be back to pre-waiver conditions, that Johnson Memorial chose to willfully ignore those announcements. The evidence will show that there have been at least 2 other cases in 2022 of other Connecticut hospitals being fined for ceasing to provide inpatient services without a CON, Wyndham Hospital and Rockville Hospital. The testimony will show that it is hard to fathom that Johnson Memorial Hospital did not know that OHS expected them to file a CON once the waiver authority expired in May of 2021, especially since the hospital will emphasize how up to date they were keeping the OHS staff about their future plans for inpatient services. The record will also show that Johnson Memorial Hospital was aware that during the 2022 legislative session, a law was passed and signed on May 7th, 2022, that codified if an inpatient service is suspended for 180 days, it will be automatically deemed a termination. It is disingenuous for the hospital to claim it had a good faith belief that a CON was not required, since it intended to resume L&D services at some point when the labor economy improved. The evidence will show that Johnson Memorial Hospital has not offered labor and delivery services since October 14th, 2020, and that it should have started offering them as of May 29th, 2021. Therefore, May 29th, 2021 is the date from which OHS should assess the civil penalty of $1,000 per day. In conclusion, the Office of Health Strategy will show that Johnson Memorial Hospital knowingly and willfully failed to either seek a CON or resume offering labor and delivery services once the temporary waiver program expired. The hospital knew the law, willfully broke the law, and should be assessed $1,000 per day as a civil penalty. Thank you.
Thank you, Attorney Manzione. So we're going to turn to your evidence and witnesses now. Can you please identify all individuals who you plan to have testify today?
Yes, I am only planning on calling one individual, and that is Mr. Steve Lazarus. Steve, well, I think he's here, and I'm sure he will spell his name and do all those other things he's supposed to do.
Okay. Mr. Lazarus, can you spell your last name, and actually your first and last name, and also provide your title?
Sure. Good morning. My name is Stephen Lazarus, STEVEN LAZARUS, and my current title is Certificate of Need Program Supervisor.
Thank you. Mr. Lazarus, can you please raise your right hand? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you provided in your pre-file and the evidence that you shall give in this case shall be the truth, the whole truth, and nothing but the truth? So help you God, or upon penalty of perjury?
I do.
Okay. And do you adopt the testimony that was submitted on your behalf, I believe, yesterday?
I do.
Okay. You can proceed with whatever additional testimony you plan to provide today, whenever you are prepared to do so.
Maybe perhaps first we should just address the foundation of the document labeled OHS Exhibit Number 2.
Okay.
I can ask a few questions about it, but then I will be happy to pass it over to Attorney DeBasio for any questions he might have. So I'm going to ask Mr. Lazarus, I'm not sure if you have in front of you or if you were able to put in front of yourself an exhibit that was uploaded last night. So it has been marked as letter R in the record. Do you have access to the portal right now?
I do. I have it open in front of me.
Okay, great. And do you have it open to
Second.
okay, now I'm just pulling it up myself too. Okay, can you explain what this document is, what the title is, and what the document is?
Sure. The title of the document is Guidance Regarding the Expiration of the Temporary Waiver of CON Requirements of Approval of Increased Beds Capacity and Temporary Suspension of Services at Connecticut Hospitals and Outpatient Surgical Facilities during COVID-19 Public Health Emergency, and is dated October 22nd, 2021.
Okay, and what can you tell us about this document?
This was a document that was put out by OHS on that date. This basically clarifies OHS's position on the Executive Order 7B that was issued and when it expired.
And how was this document distributed or made public?
So I was not directly involved with it, but typically when a document that is put forth by OHS, similar document, they normally would be sent out via email to all hospital leaderships. Traditionally, it's the CEO office emails, but I would have to check and confirm in this particular case if that was done, but typically that's where it's done.
I noticed in the title, it says temporary suspension of services at Connecticut hospitals and outpatient surgical facilities. You mentioned that it would be emailed to hospital leadership. Would it be emailed to any other leadership?
Outpatient surgical facilities as well. And it would be emailed out.
And would it be posted in any other place where members of the public, interested parties might be able to see it?
It probably was posted on our website as well, but I did not confirm it myself.
And are you the author of this document?
I am not.
Do you know who is the author of this document?
I believe it was our, it was the executive director's office, but it was worked on with our general counsel at the time, which was Damian Fontanella.
And do you know where Damian Fontanella is today?
Unfortunately, he passed away about a year ago.
Okay, thank you. I'm sorry about that. Okay, so I would say if Mr. DeBasio has any questions, if he wants to conduct any voir dire.
Sure.
Through you, Hearing Officer Chuka.
Yeah, I was waiting for him to take himself off mute. Attorney DeBasio, if there is any further follow-up on that, you can ask those questions.
Thank you. Just briefly, Mr. Lazarus. So I believe you testified a moment ago that the normal means of publishing this document to the affected hospitals was via email to those hospitals, correct?
Yes.
And you're not sure if this was actually posted on the OHS website, is that correct?
I have not confirmed it, no.
So as you sit here today, you don't know if it was made publicly available via any other means other than emailing it to hospital administrators?
I do not.
And you have no knowledge as you sit here today that this document was actually emailed to anyone at Johnson Memorial Hospital?
I was not part of that process, no.
Thank you. Based on that, Your Honor, I'd object that there's no evidence in the record and the witness can't testify that Johnson Memorial Hospital has ever seen or received this document. And the witness has no actual knowledge that it was ever published or made public to anybody through the OHS website.
Ms. Manciano, do you have any response to that?
Mr. Lazarus, is there anyone that is currently available who might be a better source of information about how this document was distributed or advertised, publicized?
It would most likely be the executive assistant who may have been involved in distributing this document.
And who is that?
I believe it was Maida Capozzi at the time, but I'm not sure.
Okay. Well, if it's important, we can certainly see if we can get Ms. Capozzi to testify. I know her, and I know that she is working today. I'm not sure if we can have her sworn in to answer some more questions about this.
So do you have further follow-up or further questioning for Mr. Lazarus? Or is he planning to do further testimony right now?
Oh, I wanted to go just, yes, I wanted to just emphasize a few things from his testimony before I let go before I stop presenting the case. So if you want me to continue with Mr. Lazarus, I'm happy to do that.
I think maybe if you're going to be referring to this document, maybe we should take maybe a 10-minute break to see if you can get someone to verify the source of the document. So, because I'm I don't want to exclude it if you think you may have a way to get it in.
Sure. Then yes, we would appreciate a 10-minute break to check with Maida Capozzi and see if she has better knowledge and if she's available to be sworn in and testify about this document.
And Your Honor, just for the ease of the proceedings, I'm prepared to ask Mr. Rosenberg if he's seen this document as well. I didn't mean to ambush Attorney Manzione. I got this last night and haven't had a chance to talk about it with my client. So,
Okay.
you know, to the extent Mr. Rosenberg received the document and seen it and saw it prior to this hearing, obviously would have no objection then. But as I said, I didn't have a chance to independently verify that before we started.
Okay, so let's take 10 minutes and see Attorney Manzione and Attorney DeBasio if we can come to some sort of resolution as to whether this document should be allowed in. And we will return back at 10:25.
Thank you.
Steve, I'm going to log off and call you.
And we'll have a discussion. All right, thank you. We are back. Attorney Manzione, do you have any way of proving that this was published to JMH?
So we checked with the witness, we checked with the staff person who we thought would have been the person to do it. She could not find any evidence or records in her system, so we are not able to prove that through our possible, it might have been sent by somebody else, but the person who we thought was the most likely to do it doesn't have any record of it. So unfortunately, we don't have the ability to prove that right now.
Okay.
And Your Honor, to the extent it may aid in the presentation, Johnson Memorial Hospital is prepared to stipulate that they've seen this document before, but we're not prepared to stipulate that we saw it on or about October 22nd, 2021. So to the extent OHS wants to offer it for any other purpose other than notice to Johnson Memorial on that particular date, we have no objection to it coming into evidence. But to the extent OHS wants to offer it for the purpose of establishing knowledge on behalf of Johnson Memorial Hospital on that date, my witness has no specific recollection of seeing it at that time, only that he's seen it prior to this hearing.
Okay. Attorney Manzione, what is the way in which you intend? Well, I'm going to allow it in for right now, and if it seems as though it meets that qualifier that you just mentioned, Attorney DeBasio, I'm going to exclude it. Does that make sense to everyone?
Yes.
Okay. So that'll be a full exhibit for right now, but it may change at some point in the future. Attorney Manzione, you can proceed with your case.
Okay. So I would just like to pull out a few things from Mr. Lazarus's written testimony. So if he can be called back to the stand, I don't know, he's still under oath. I'd like to be able to see you, Steve. I'm not sure how I get to see you on the screen, but.
My camera?
There you go. Yeah, there you go, when you speak.
Okay.
Okay. So, Mr. Lazarus, so can you remind us again, what is your position at OHS now?
Sure. I'm currently the CON program supervisor.
And what do you do now? What is your role? What are
Currently,
the job activities that you do?
so I currently have a staff of 5, but will hopefully grow to about 7 by the end of the year, we hope. There are various analysts and various types of background titles. There are research analysts, planning analysts, as well as healthcare analysts. And they review CON determinations, CON applications, most of the material related to the certificate of need. I make sure that we meet all the legal deadlines, we get the completeness reviews conducted and process the applications.
And were you involved with the CON process during 2020 or 2021? And if so, in what capacity?
I was not directly involved, but I was involved in certain subject matters when they needed assistance. Mostly in the process piece when they needed.
And when you say the process, what does the process mean to you?
More of the legal process that's delineated in under 638 and 639. So we try to follow those processes as well as training for the staff.
Okay. And in terms of 19A-638, how familiar are you with that statute?
Well, I don't have a visual perfect memory, but I'm rather comfortable with it. If I have it, I use it many times to sort of help guide the CON determinations and applications, whether they're required or not.
Okay. And do you know what 19A-638A5 is?
I believe that's the one with the termination of the service by a hospital, acute care hospital.
And so the overall prescription of 19A-638, the introductory words are a certificate of need is required for blah, blah, blah. So what does that entire section 638A5 mean?
Objection, Your Honor. The statute speaks for itself. I mean, his interpretation of the statute really isn't at issue here.
Okay. I will withdraw that. So, Mr. Lazarus, hold on one second, I apologize here. Mr. Lazarus, in your knowledge, has OHS ever imposed civil penalties on hospitals for failure to seek a CON that is required?
Yes. I think most recently, I believe it was Sharon Hospital, perhaps. So, oh no. They have been done. Civil penalties have been assessed probably recently, but also probably about 10 years ago. There were a couple of cases.
And do you know, in your experience of the civil penalties that are imposed, how much of a civil penalty, like an amount, a dollar amount per day, has been imposed?
Objection, Your Honor. To the extent she's asking him what he's read, he's really not, so it shouldn't be through his testimony. If she's trying to qualify him as an expert in terms of assessing the penalty and what sort of criteria OHS uses, there's no foundation for that at this point to indicate that he's qualified to do that.
Attorney Manson, do you have a response?
Well, I don't really think we're going to need to go through and qualify Mr. Lazarus as an expert, even though I think he probably would meet that criteria. Let me just see if there was anything else I wanted to pull out of his written testimony.
So you're withdrawing that question?
I'm withdrawing
Okay.
that question. I apologize. Yes, I'm withdrawing that question. Okay, so the final question for you then, Mr. Lazarus, is after the second executive order issued by the governor, Executive Order 12B, which was the executive order that ended the special authority given to OHS to bypass the CON. Do you know, did you get an influx of CON requests through the portal? If you know,
Objection, Your Honor, relevance.
I'm going to allow it. I'll give it due whatever weight the response is due.
so Mr. Lazarus, do you know if there was an influx at that time when the executive order expired?
Your Honor, I'm also going to object that the time frame isn't specific here. I mean, from the time the executive order expired to the time this penalty was imposed was over a year. So to the extent we're talking about an influx within a certain period of time, I think we should define what that period of time is.
Okay, fair enough. I will say, do you know, Mr. Lazarus, if there was an influx of CON filings in the time period for the month after the executive order expired? So that would have been from the last day of May in 2021 to the last day of June in 2021. So for about the month of June. Do you happen to know? I'm not asking you to look anything up. Do you happen to know? Do you recall?
I don't, no, I don't know.
Okay, that's all I have for Mr. Lazarus. Thank you.
Okay, Attorney DeBasio, you can do cross-examination of Mr. Lazarus.
Morning, Mr. Lazarus. My name is David DeBasio, and I represent Johnson Memorial Health in the proceedings today.
Good morning.
Morning. I'm not going to take up too much of your time. I just had a couple of quick questions. So do you have a copy of your written pre-filed testimony in front of you?
I do.
If you would be so kind as to go to page 3 of that testimony, and I'm looking specifically at paragraph 5 that reads, OHS even circulated guidance in July of 2021. Do you see where that paragraph starts?
I do.
Is that guidance that you're referring to there, the guidance at the top paragraph, guidance 21-002?
Yes.
So it wasn't circulated in July of 2021. It was circulated in October of 2021, correct?
Correct.
Your Honor, to the extent that that information is already covered in the first paragraph of Mr. Lazarus's testimony, I'd move to strike paragraph 5 of his pre-filed testimony, just because it's if we are creating a record and you go back to it, it gives the inaccurate impression that there was a separate guidance issued in July of 2021, when I believe that paragraph should read, based on Mr. Lazarus's testimony here today, October of 2021. And I don't believe it would prejudice OHS because that information is contained, as I mentioned, in the first paragraph on that page.
Before you roll, Hearing Officer Chuka, I would like to ask Mr. Lazarus, do you know if there was an additional separate guidance document circulated in July 2021?
Your Honor, before he answers that, object, because he just testified that that reference in that paragraph was to the October guidance. So whether there was or was not a separate guidance issued in July of 2021 is irrelevant to what we're talking about with regard to this particular piece of testimony.
I have to disagree with the characterization of Attorney DeBasio's characterization of what Mr. Lazarus said. I think he spoke quickly. I would just like Mr. Lazarus to have time to consider whether there was or not. I do not know the answer. I'm just trying to find out. Obviously, the record is not particularly clear, and we could do a better job keeping records. So, Mr. Lazarus, if possible, do you know if there was another quote unquote guidance document issued in July of 2021?
I don't have any knowledge of that.
Okay. Then that's fine. We can assume that that was an error, that it should have been October 21.
Yeah, I'm not going to strike it, but I am going to take note of the fact that that was an error.
That's fine, Your Honor. And again, I'm not trying to impugn any improper motive on anybody, but since this is a heavily stipulated to case, and we're submitting all of this in terms of a record, I didn't want that particular milestone in that testimony to be misconstrued, when you're writing your decision days or weeks from now, when I believe it's clear that, and I'm only basing it on what Mr. Lazarus said, that his understanding was that that was the October guidance.
Understood.
Thank you. So, Mr. Lazarus, you talked about how you're familiar with the CON process, correct?
Yes.
Are you involved at all in the penalty process in terms of determining when to impose a penalty and how severe a penalty to impose?
I am not.
Do you know who in your office is involved in that process?
I'm not directly involved in the process. I'm not sure all the parties are involved or all the persons.
Not going to object to any further answering on that question because we've already established that Mr. Lazarus is not an expert in this area. Unless you want to try and do that. I don't think he's got the information that you're seeking.
I wasn't asking him an expert question. I was just asking him if he knew who in the office was involved in the penalty process.
And he said no.
I'll allow the question. And Mr. Lazarus, can you just confirm that you don't know?
I do not know.
Okay.
So I have nothing further.
Okay. Ms. Manzione, did you have any redirect for Mr. Lazarus?
No, just thank you for your testimony.
Thank you.
Okay. Mr. DeBasio, are you prepared to move forward with your opening statement? Or would you prefer to take a 5-minute break just to regroup?
I just want to make sure that Attorney Manzione has concluded her presentation.
Yes, I don't have any other witnesses and all of the documents have already been submitted, so I'm concluded my presentation.
Thank you. It's up to you, Your Honor. I don't know if you want to take a break at 11 anyway, so we'd be taking it now. We just took a break 20 minutes ago to deal with that other issue. I don't expect, I don't know if you want me to make my opening statement, deal with Mr. Rosenberg's testimony, and then we can take a break and do closing arguments, or how you want to proceed.
Sure. Yeah, no, we can do that. Let's just move forward.
Thank you, Your Honor. I'm going to be extremely brief with regard to my opening statement because given the condensed nature of the hearing, you're going to have my closing statement in about a half an hour. So, suffice it to say, I compliment Attorney Manzione because she highlighted what Johnson Memorial's defense here is going to be, that the facts really aren't in dispute. I'm not going to take a lot of time marshaling the evidence because it's before you, other than to say Johnson Memorial took tremendous efforts during this very uncertain time to recruit and staff labor and delivery services there at Johnson Memorial. They did keep OHS updated on what was going on. They were in constant communication with them. They actually recruited nurses that it was with the intent for them to go and work at Johnson Memorial Hospital. They were trained at St. Francis Hospital. And then when they completed their training, they didn't, quite frankly, want to go work at Johnson Memorial Hospital. So this wasn't a situation where Johnson Memorial Hospital willfully terminated labor and delivery services. They didn't have the intent to walk away from those services. They had the intent to resume those services. The pandemic affected that. Their mistaken belief that they could actually achieve the staffing levels they needed to provide those services affected that. The labor market affected that. And their inability to actually achieve those staffing goals affected that. So you as the hearing officer are entitled to consider not just the fact that the services were not provided. I mean, the statute specifically provides that you can consider the facts and circumstances surrounding that. You can even consider the fact that Johnson Memorial eventually filed the CON itself as a reason to reduce, revoke, or rescind the fine. And that's our submission here today, that if you look at this in a vacuum and simply say, as of May 2021, the services were not provided, therefore we're finding you $1,000 a day, is completely inequitable in this situation where Johnson Memorial did not terminate the services. They were unable to provide the services. They made tremendous efforts to provide those services, and those efforts just didn't bear fruit. That's the conclusion of my opening statement.
Okay. Thank you, Mr. DeBasio. I believe you said you have one witness. Is that correct, Mr. Rosenberg?
That's correct, Your Honor. That's Mr. Rosenberg. And Mr. Rosenberg's testimony was filed with OHS on November 2nd, 2022. I believe I indicated in a cover letter to you that's part of the record that Mr. Rosenberg was unable to sign his testimony at that point due to a family circumstance that rendered him unavailable. Attorney Manzione didn't have any objection to us filing the unsigned testimony at that point. And Mr. Rosenberg, I do have a signed copy if you would like me to submit that as part of the record to correct that exhibit. But I believe, you know, if you canvass Mr. Rosenberg, he's prepared to adopt that testimony that was submitted on November 2nd, 2022 as unchanged.
Okay. That should be fine. I don't think there's a need for you to file the signed version. So I will move on to Mr. Rosenberg. Please unmute your device, sir. Okay, thank you. Can you please state and spell your name and provide your title as well?
Absolutely. Stuart Rosenberg, S-T-U-A-R-T, Rosenberg, R-O-S-E-N-B-E-R-G, President of Johnson Memorial Hospital.
Okay, thank you. Please raise your right hand, sir. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
And do you adopt your pre-file testimony? Oh, thank you. You could put your right hand down. Do you adopt your pre-file testimony?
Yes. Yes, sir.
Okay, thank you. So Attorney DeBasio, you could either proceed with questioning, or Mr. Rosenberg, if you planned to just make an opening statement, you could do that, whichever you'd prefer.
Your Honor, with the admission of Mr. Rosenberg's testimony, that's the conclusion of our evidence. Assuming, and I believe we dealt with this at the beginning, we don't have to move our exhibits into evidence because they're already full exhibits.
Correct.
Then
Okay.
with the exhibits in Mr. Rosenberg's pre-filed testimony, that's the respondent's evidence for this hearing.
Okay. Did you have any additional questions you wanted to ask? You will have an opportunity to do redirect, but for right now, is there any direct examination?
No, Your Honor.
Okay, thank you. Attorney Manzione, did you have any cross-examination of Mr. Rosenberg based on the testimony that's been submitted?
I do have just a few questions, and I think they'll be relatively painless. I'm looking at the Mr. Rosenberg. I am looking at a printed copy of your direct testimony. I'm not sure if you have access to a copy of that or if you can see it on your screen somewhere. I'm curious about the third sentence in the first paragraph, the one that starts with JMH has been fined. Do you see that, sir?
Yes.
Okay. Can you just read that sentence for me? I think I might be misunderstanding what the point of that sentence is. Can you please read that sentence to me?
JMH has been fined for its alleged willful termination of labor and delivery services with filing a certificate of need. JMH has,
Okay, no, that's enough. Do you mean to say with filing a certificate of need, or do you mean to say without filing a certificate of need?
Would you repeat that last part of your question?
Sure,
With-
I'm curious if the word with is supposed to be without. Sometimes it's just a typographical error.
Without. I think that's the issue here.
Exactly, and I wanted to make sure we were clear is what the issue. So would you reconsider that sentence? And if you were going to state it again directly, how would you state that sentence?
Without adding any words.
Or just,
Yeah, I mean, JMH has been fined for its alleged willful termination, which I don't agree with. I mean, the term willful, I think we're going to talk about that.
yes,
Termination of labor and delivery without filing certificate of need.
okay. All right, so yeah, I'd like to, that's what I thought it should be. I think that was a typographical error. Very confusing sometimes when there's double negatives, so, okay. Mr. Rosenberg, do you know when the last time a labor and delivery services were provided at Johnson Memorial Hospital?
I believe it was October of 21.
October of 2021?
You're talking the last delivery? Is that what you're
Yeah,
speaking?
when was the last time you had in hospital? October of 2021.
On or about, yeah.
And so that was about a year ago. How long were those? So that was the last time. So have any births occurred at the hospital since then?
No,
Okay. And would you say, Mr. Rosenberg, that you are familiar with the role of OHS, the Office of Health Strategy, as a healthcare regulator?
yes,
Would you say that you are familiar with some of the certificate of needs statutes and regulations that OHS is charged to enforce?
globally, but not with all the detail.
Okay, if you didn't know what a specific requirement or regulation was, what would you do if you needed to know the answer about, should I do something? Do I need to ask OHS for permission, for approval? Who would you ask if you didn't know?
I'm going to object just to the extent that this may call for information covered by the attorney-client privilege. But to the extent, I want to be clear before Mr. Rosenberg answers, just to the extent he's going to identify an individual, I'm not claiming the privilege with regard to that, but he can identify an individual, but I will object to any questions about the topics, the nature, and the advice and the substance of their discussions. And I'm going to instruct Mr. Rosenberg based on that. If we can limit the question to the individual, then that's fine.
I don't think that's where Ms. Mincione is going with this, but I could be wrong. But I agree with you, Attorney DeBasio. Mr. Rosenberg, just be careful not to discuss any conversations, the specifics of any conversations you may or may not have had with legal counsel.
And I agree counsel's question wasn't in that vein, but if I don't object before he answers, the cat's out of the bag.
Understood.
All right, let me rephrase this. So, Mr. Rosenberg, if you have a question about CON statutes and regulations, would you ask someone about it? Is there somebody who you might ask?
Yes, and there is specific individuals that I would ask within Trinity Health of New England who supports our hospitals in this area.
I'm sorry, you spoke quickly.
I said we have individuals within Trinity Health of New England who I would contact for questions with respect to this area.
And without violating any of the substance of what you might ask them, who are those types of people? If you know their names, what role do they have? Are they a strategic officer? Are they a financial position? Are they an attorney? What type of person?
I think I would call it a strategist and legal counsel.
And you say that there are people who have these titles who work for Trinity Health, which is the parent company of Johnson Memorial Hospital?
Trinity Health of New England is the owner of Johnson Memorial Hospital.
It's the owner, okay. And would you say that the Trinity Health of New England, the staff who work for them or the officers who work for them, give you good information when you ask questions about policy or strategy?
Objection, Your Honor, to the extent that that's calling for him to discuss information he may or may not receive with legal counsel. I think it's inappropriate.
I'm asking the witness if he believes that he has good information from the people he asks. He has said he speaks to a strategist and legal counsel. So if you're uncomfortable with me including legal counsel, I will ask about the strategist.
I think if she wants to limit it to the strategist, that's appropriate. But if she's asking him what his feelings are about the advice he's getting from legal counsel, I think that's invading the attorney-client privilege.
I'm inclined to agree. So if you want to ask specifically about the strategist, that's fine.
Mr. Rosenberg, have you asked the strategist who works for Trinity Health information about the Office of Health Strategy requirements, regulations, statutes? Have you asked the strategist who works for Trinity Health?
Yes,
And would you say you have received information from the strategist that you feel is reliable?
yes,
And would you say that you have asked the strategist questions about OHS regulations, requirements on more than one occasion?
multiple occasions, yes.
And would you say that that person or persons are pretty knowledgeable about OHS rules?
Yes,
Okay. My other question deals with, okay, I'm sorry, deals with the imposition of civil penalty. Your attorney has suggested that the penalty imposed is too high and that it should either be rescinded or minimized or mitigated. On what grounds should the penalty be reduced or mitigated or rescinded?
Objection, Your Honor. That's a legal argument. I mean, the facts are submitted in this case, and now she's asking him to make legal arguments on behalf of Johnson Memorial.
So I am asking, one second, I'm going to his testimony for here. Okay, I will stop asking him about that. I will withdraw that question. Let me ask you about some of the recruiting that you did or that that the hospital did. Can you tell me about the recruiting efforts that the hospital did to try to staff the labor and delivery services for the hospital?
sure. Our talent acquisition team went out to several websites, schools, to recruit nurses in this specialty. And it is a specialty. And we offered incentives for hiring, like a lot of other hospitals in the state are doing, sign-on bonuses, referral bonuses. And we put all our resources into this initiative.
And what kind of, so you said you offered incentives, sign-on bonuses, referral bonuses. Do you happen to know about how much those were?
Objection, Your Honor, relevance.
I'm curious to find out how much emphasis the hospital placed on recruiting. One of the arguments of the hospital is that it was unable to fill these positions. I'm wondering, you can say that the hospital offered an incentive of $100, and that would probably not be that much of an incentive. I'm curious if the hospital offered an incentive of $1,000, $10,000. It's been a very tough time to try to recruit workers. We've heard this across the industry from all sorts of representatives of healthcare workers, especially in more rural parts of the state. I'm curious as to how much money the hospital thought would be enough to incent workers to come and work at the hospital.
Well,
To the
respectfully, Your
extent that he knows.
I mean,
with all due respect to counsel, Your Honor, curiosity aside, the OHS's position is that our defense of this is meritless. So really going down this road as to exactly in terms of dollars and cents what they did doesn't go to making OHS's case in chief. And I think it's a red herring, and it's going down a road where, unless you can put it into context as to what was going on at that particular time or what other hospitals were offering, it's a number that's going to be completely without context in this scenario.
I'm going to allow the question because I think it may be relevant. But as you indicated, Attorney DeBasio, I don't want to go too far down this path. So Attorney Manzione, if you want to ask the question again.
Certainly. Mr. Rosenberg, do you happen to know the possible range of bonuses, either sign-on bonuses or referral bonuses that were offered to potential employees in 2020, 2021?
let me answer the question in the sense that compensation and bonuses are pretty protected, as we have to be careful how we promote that. You notice there's not a lot of that in the advertisements we do, so I'm going to be cautious with this, Counselor, if that's possible, Dave, because we got to be mindful of certain historical aspects of compensation and bonuses. But I will say they're extremely.
Well, with that, Your Honor, I mean, if we're going to pursue this, maybe we didn't anticipate going into executive session, but this may be appropriate for executive session if it's going to put Johnson Memorial Hospital at a competitive disadvantage to its peers in the marketplace by talking about this in an open forum such as this.
Right.
I don't think we need to go into executive session to the extent that this information is private or confidential. I find that hard to believe that you would not make it widely known that if you come and work for us, we will give you a $5,000 sign-on bonus. That's something you want people to know. That's something you want people to talk about, especially in context of a referral. So I really find it hard to believe that we wouldn't want that information to get out. The reason I'm asking this is because I am curious how hard the hospital has tried to recruit for these specialized positions. Yes, it does not go to my case in chief because I believe that your entire argument is meritless, but to the extent that the hearing officer might prove or might believe that, well, it was tough to hire people, I want to try and chip away at the fact that you did not do everything within your power. You did not offer enough money to try to recruit people. You did not go to the ends of the earth to try to find workers here.
But
So
again,
my question remains, what kind of dollar amount was offered?
But again, Your Honor, if we're not talking about, we don't have any evidence of what other hospitals were doing recruiting those same individuals at the same time period, it's a meaningless benchmark for the purposes of this hearing.
I think the hearing officer can make the determination about how much people have been offered as recruitment bonuses or sign-on bonuses. This is not a new topic of conversation. This has often come up in other hearings on whether we are able to staff the hospital. This is not the first time this problem has come up.
It may
Well,
not be the first time this problem has come up, but there's nothing in the record, in our record in this particular hearing today, about what a milestone or what a benchmark would be for those types of things. And milestones and benchmarks that may have existed prior to the pandemic are not the milestones and benchmarks we're talking about during or after the pandemic. The entire labor market changed. So again, to the extent that we're talking about this in a vacuum, I don't think it's probative of the issues before Your Honor.
okay. Let me just start by asking Mr. Rosenberg, do you even know the answer to that question before we?
Yes.
Okay. I don't know. It sounds, Attorney DeBasio, like you're claiming executive session may be appropriate because this will fit into one of the exemptions under the FOI regarding, trade secrets and things of that nature. I don't know if we can physically go into executive session because I've never had to do that before. So I'm going to have to take a 5-minute break just to actually let's say.
I will withdraw my question. I don't want to prolong this. It's not essential to my case. How much of a referral bonus? It's fine if we don't get that information out. I think I've made the point that there's always more that a recruiter or an employer could do to try to find more workers. You could pay more money, but I don't want to testify. I am just asking the question, and you don't want to answer it outside of executive session, so I will just withdraw it.
Okay. Thank you.
Okay. I don't have any more cross-examination.
Okay.
I have no redirect, Your Honor.
All right. I actually did have a couple questions for Mr. Rosenberg and Attorney DeBasio. I'll let you do some follow-up if you have any, just to clarify. But we were sort of getting into the extent to which Mr. Rosenberg understood the executive orders and things of that nature. So, Mr. Rosenberg, do you have any legal training or education?
Yes.
And can you just tell me a little bit about what that is?
Just it's classwork in business legal principles and healthcare administration.
Okay, but you don't have a law degree per se?
No.
Okay. And you just to confirm, earlier you testified that when it comes to your understanding and analysis of the CON requirements, you defer to either internal general counsel or outside counsel. Is that correct?
Yes, Your Honor.
Okay. Can you just turn to page 7 of your testimony? There's something I wanted to ask you in there. Just let me know when you're ready.
Does that have a number? I'm looking at the testimony that's attached to the to Attorney DeBasio's brief. I think it's part of the same document. It's in Mr. Rosenberg's testimony, starts on page Bates stamped mark number page 14. So would that be page 20?
Sorry, I'm looking at Exhibit J.
Okay, Exhibit J. Okay, I think you're talking about,
Yeah, it's JMH 000020.
okay, yeah, thank you.
Okay.
Okay, Your Honor.
Trying to find, so the last sentence of the first full paragraph, it says ultimately the board of directors of JMH's parent company made the difficult decision on June 29th, 2022 to seek approval from OHS. Do you see that?
Yes, sir. Yes, Your Honor.
And then in the next paragraph, it says on June 29th, OHS filed. Do you see that as well? Just read through that for a moment. And let me know when you're ready.
Yes, I'm ready, Your Honor.
Do you know which of those occurred first, the decision or the issuance of the civil penalty? If you don't, that's fine. I'm just
thinking of the timing, Your Honor, that I believe the local community board made the decision because we had to go forward with the decision to terminate services to file a CON. And then post that came this. That's my, I have to go back and look at more detail.
okay. That's fine. Um,
I'm sorry, at hearing officer Chuka, I don't understand what Mr. Rosenberg said. Can he just restate what happened first and then what happened?
Well, it says the board of directors, you know, we had to go through the process before we can get to there were two things going. You got the civil penalty, we have the determination, the decision to file a CON, and then we had to go, as it said here, to the parent company board, and then OHS files its civil penalty letter, then we did our work there. So everything came, the board meeting went first, and then the second June 29th statement came second. And then the third was the result of all that on September 29th. I think that's the time frame.
but you're not certain, it sounds like,
No,
based on your own independent recollection of the events.
I'm certain that the board meeting went first,
Okay,
and then came the next, then came the next. That's the kind of sequence of events that occurs. But without checking minutes of meetings and going in and looking at that myself, I mean, I can do that. But this is what I recall.
okay. And one other question for you, if you can pull up Exhibit F of your pre-filed testimony. I guess that's Exhibit F to the brief or your pre-file.
Just for ease of the record, the exhibits are, the identification is the same throughout the affidavit and the brief.
Okay. Thank you. Do you have that, Mr. Rosenberg?
David, that's F in the binder? Or-
Yes, Stuart, that's F in the binder.
Yes, sir.
And just for the record, so everybody understands, for the ease of this hearing, I sent Mr. Rosenberg a binder with a hard copy of all of the exhibits that JMH has submitted as part of the record here. So he's not referring to anything other than a printout of the materials that have already been provided to the hearing officer in OHS.
Okay, thank you.
I have it.
Okay, thank you. Do you recall when you first, so it's dated November 2nd, 2021. Do you recall receiving this?
Yes,
And to the best of your recollection, was it on or about November 2nd, 2021?
on or about, because it came through, through the portal. So yeah, on or about that. That's how we became knowledgeable.
So if you could just look at the last full paragraph, it's on JMH 000199. The paragraph beginning, given that the hospital.
Okay. Yes, Your Honor.
If you can just read through that to refresh your recollection as to the content of that paragraph and let me know when you're ready, I would appreciate it.
Sure. Okay, Your Honor.
Now, do you recall reading that paragraph when this letter came in?
Yes.
And then if you look at Exhibit G, which is the next exhibit to your testimony, that's the November 30th, 2021 response that you signed your name to.
So,
Can you just take a moment to look at that document as well?
okay, Your Honor.
In that letter, did you object to Ms. Martone's statement that JMH was in violation of the CON statutes?
I don't know, I specifically objected. We stated that we didn't plan to terminate because we wanted to continue to recruit for nurses so we can provide a quality program here at Johnson for the community.
As you're looking at that, though, you wouldn't characterize your letter as stating that you were disputing her statement that JMH was in violation of the statutes?
I think we continued on with our previous statements to OHS about recruiting, and we, I know there was a decision point about whether you want to terminate or not terminate, but we felt that we were going to be able to recruit a critical number of staff so we can offer this service, a quality service to our community.
Okay. Thank you, Mr. Rosenberg. Attorney DeBasio, did you have any questions you wanted to ask of Mr. Rosenberg, given my questions?
No, Your Honor.
Okay. All right. I'm going to suggest that we take a 10-minute break and then come back and do some closing arguments and then wrap up the hearing. So let's come back at 11:30. And again, I would encourage you all to mute your devices and turn your video off until then. So, thank you and see you shortly. So before we get into closing arguments, I did want to ask one question of you both. Attorney DeBasio, I saw that you filed a legal brief on, I believe it was November 2nd. Did you, So Attorney Manzione, did you want an opportunity to also file a legal brief?
I would certainly like the opportunity to file a brief. I don't want to put opposing counsel at a disadvantage. I know that he already filed one, but I wouldn't be opposed if he wanted to file a post-hearing brief as well.
That was going to be my second question. So it normally takes about 1 to 2 weeks for us to get the transcript back. Do either of you, do you think that it would be reasonable to set maybe a 30-day deadline following the receipt of the transcript? Does that seem reasonable?
I'm just cautious of the time of year that it is. It's November 16th. There's Thanksgiving coming up. There's Christmas, Hanukkah, New Year's. I just know it's a very busy time for many people. And I'm not sure how the 30-day deadline would fall.
Okay. Attorney
I would-
Bassio, do you have any thoughts on that?
Your Honor, I don't disagree with Attorney Manzione, and I think if we could all agree today that we'll look at when the transcripts come in, and if the 30 days is going to land somewhere around the holidays, we can agree that they will be due January 15th or something like that, or I'd be prepared to, my hesitancy is if this period, if we do not prevail and this period is going to be counted as part of the period in terms of assessing the penalty, I don't really want to push this off, indefinitely. So that's my position. I agree with the holidays and everything. I want to be accommodating,
Okay.
but one of my questions would be, if we do not prevail in this hearing, if we're going to do this, can we stipulate that this period of time is not going to be counted if Your Honor decides that you are going to impose a penalty?
So
I would have no objection to stopping the clock if that's what we're talking about, of the penalty continuing.
okay. Correct me if I'm wrong, but I think the statute says willful fail to file an application for a CON, and your client already has filed that application, and you actually attached it as an exhibit to your filing, right, Mr.
Well, yes,
DeBasio?
Your Honor. I believe there's an argument that all of it stops as of the date of the con application, the CON application. But I recognize that the statute, the statutes have changed, and the approach, the global landscape has changed since the pandemic. So without presuming that the filing of the con on September 29th should stop any accrual of the penalty, which I'm not asking anybody to make a ruling on today. I believe that is the case, though. I would certainly not want any extension of these proceedings to be tacked on, so to speak.
I agree with Attorney DeBasio's characterization of how things can be interpreted. I personally think that the civil penalty statute, the 653, states that if you willfully fail to seek a certificate of need approval, and obviously his client, the hospital, has sought that certificate of need approval. However, there's a little bit of a disconnect with the 638 requiring the certificate of need to be granted before actually doing the activities. So I think there is a little bit of possibility for interpretation that's different. So I would
Okay.
have no problem pausing, hitting a stopped key, so no further time or penalty accrues during this waiting time or writing period.
Okay.
And I don't think Attorney Manzione and I were anticipating this was going to be the seminal case to clear up that ambiguity.
Okay.
So that's again the only reason, and I'm not trying to bind OHS, and I'm not looking at her position as an admission or anything, but that's my concern.
Okay. If you're both willing to stipulate to a pause, I think that'll work. So I guess we'll just treat today as the first date of that pause, to the extent that it's necessary, and we will figure out the briefing schedule at a later date once we've received the transcript. Does that sound reasonable to both of you?
Yes, Your Honor. And again, that's without waiving any right to claim that the pause isn't necessary if we have to, because it should have stopped. But,
Correct.
and I believe if Your Honor is comfortable with it, when the transcripts come in, I don't think Attorney Manzione and I are going to ask for 6 months, so that we may be able to submit a joint submission that we agree brief should be submitted by January 13th or whatever. And unless you disagree, I'm just trying to spare you setting up a scheduling conference with us if it's not
Yeah.
necessary.
I think it's probably something we can do by email.
Perfect.
Consistent with what I did earlier this week, where I just sort of uploaded our conversation about the need for additional time. So I think the same sort of thing can be done for this. So we are going to keep the hearing record technically open. We need to have Exhibit S filed as well. So if we can get Exhibit S filed by the end of this week, that would be good.
It would be my preference to have it filed by the end of today, so
Okay.
we can beat the end of this week.
Okay. So we're technically going to keep the hearing record open until both of the legal briefs are submitted. And with that, I think we are ready to proceed with closing arguments. So we're going to start first with Attorney Manzione, since OHS has the burden.
Okay. Thank you, Hearing Officer Chuka. As I said in my opening statement, typically, if a hospital wants to cease providing an inpatient service, it must file a CON application with the Office of Health Strategy before stopping that service, so the regulator can evaluate whether the hospital should be allowed to do so. And if a hospital terminates an inpatient service without a CON, it is a violation of law, and the hospital is subject to a penalty. But this is not what JMH did. Johnson Memorial Hospital acted like they should not have to follow the law requiring a CON before terminating an inpatient service as important as labor and delivery. Johnson Memorial Hospital would have us believe that they did not willfully fail to follow the law, but rather they had a good faith misunderstanding of the law or a misunderstanding of the labor market. They claim that their misunderstanding was that because they never intended to terminate, only suspend the labor and delivery services, that they shouldn't need to file a CON. But that is not what the law requires. The law is clear. In order to terminate an inpatient service, a hospital requires a CON. We learned this morning from the president of Johnson Memorial Hospital that there are individuals who work for the parent company, Trinity Health of New England. There are individuals whom he can call to ask about questions about certificate of need process. We also heard Johnson Memorial Hospital claim that because they had a good faith misunderstanding that the labor market would turn around and they would be able to hire more staff for labor and delivery services, that they should be absolved of facing the consequences of their actions. But once again, that is not what the law requires. The law is clear. In order to terminate an inpatient service, a hospital requires a CON. The hospital must keep providing the services until a CON is approved. We also learned that Johnson Memorial Hospital was directly put on notice by letter dated November 2nd, 2021, that it was in violation of the CON statutes and regulations after the executive order expired, which allowed the hospital to cease services without a CON. But not even that letter changed the hospital's actions. Just because Johnson Memorial Hospital repeatedly said that it didn't intend to terminate L&D services doesn't matter. After all, the evidence showed that the hospital did finally file a CON to terminate L&D services on September 29th, 2022, just a few months ago. it would be inappropriate to allow Johnson Memorial Hospital to evade paying a civil penalty when other similarly situated hospitals have been assessed civil penalties for similar activities. I respectfully urge that the order imposing a civil penalty be upheld. Thank you. Oh, you're muted.
Thank you, Attorney Manzione. Attorney DeBasio.
Thank you, Your Honor. I would just note, just to pick up on one thing that Attorney Manzione said when she finished up, is if Johnson Memorial's Hospital intent doesn't matter, then the statute becomes a per se statute, and the issue of willfulness is completely taken out of it. Because willfulness means, at its very heart, that you're electing to do something with knowledge of the statute intentionally. So intent does matter. It's critical to determining how this should be resolved. Now, again, facts are not in dispute here, and I'm not going to needlessly waste everybody's time by marshaling them here. I'm just going to say that Johnson Memorial Hospital undertook steps to resume labor and delivery services once the governor's executive order expired. They actually took steps to resume those services while the order was in place. The stipulated facts and the pre-filed testimony show that Johnson Memorial was not terminating or abandoning these services. They were doing their best to actually resume providing these services. Johnson Memorial Hospital trained several nurses for labor and delivery services, and ultimately this training was so successful, they took jobs at other hospitals. So they didn't end up going to Johnson Memorial to provide labor and delivery services. Any patients that would have been going to Johnson Memorial Hospital ended up for these labor and delivery services, ended up at St. Francis Hospital receiving those services or receiving them through the emergency room at Johnson Memorial Hospital. During this time, Mr. Rosenberg has testified no doctor or nurse was laid off because of what was going on with labor and delivery services at Johnson Memorial Hospital. I'd also like to point out that, as an introduction to my closing, that the Office of Health Systems could have imposed, under their theory, a civil penalty on Johnson Memorial Hospital anytime after May of 2021. Johnson Memorial Hospital, regardless of what OHS likes to characterize it as, was completely transparent in notifying OHS of everything they were doing. OHS didn't impose a civil penalty until June of 2022, over a year after the statute expired with the waiver. So I think that also needs to be taken into account here, that when you talk about Johnson Memorial being in violation of the statute, OHS was well aware of it. OHS could have imposed the penalty or could have given the notice of the penalty at any time during that 13-month period. But they waited 13 months. And what was going on during that 13 months? Johnson Memorial, was telling them, we're recruiting, we're training, we're trying to get the service open. They are sending letters to OHS, and OHS is aware of everything that's going on. So I think it's a little disingenuous on OHS's part to say that Johnson Memorial was ignoring the law when OHS was ignoring the law and waiting until the absolute last minute to impose this penalty and letting it accrue over 13 months. Now we get back to the issue of willfulness. As I mentioned before, if intent doesn't matter, then it's a per se statute and willfulness doesn't matter. But that's not the way it's written. Willfulness does matter. We suffered an unprecedented global crisis. Mr. Lazarus himself talked about in his stipulated testimony that they had staffing issues. People left. They were backlogged. They were looking to hire at OHS. Johnson Memorial experienced the same thing. The executive orders are proof of just how drastic this crisis was and the challenges that everybody faced. Now, labor and delivery is a specific service. As Mr. Rosenberg testified to, it's a 24/7 service that has to be fully staffed and it's labor and skill intensive. So finding people to staff that service is difficult. It's not like being able to find remote workers who are going to do data processing from home. They have to be in the hospital and they have to be available that entire time. Now, this proved to be a challenge, and it proved to be an insurmountable challenge for Johnson Memorial Hospital. But we get back to the intent with regard to filing the con. I would say, contrary to what OHS argues, the November 2021 letter is proof that Johnson Memorial Hospital views this as a suspension and not a termination. They received the November 2021 letter from OHS, and they immediately responded back to OHS and said, our intent is to resume these services as soon as we get the appropriate staff and we can do it. Now, JMH had suspended labor and delivery services. That's not in dispute. So as of November 2021, JMH arguably could have filed a con or CON. OHS arguably could have filed a penalty at that point. As of January 2022, the parties were corresponding back and forth. Johnson Memorial Hospital was telling them we're still having problems providing the service. OHS knew about that. They could have filed a penalty just as easily as Johnson Memorial could have filed a con, but they didn't do that. And Johnson Memorial didn't quite candidly want to terminate the service. We're talking about penalizing a hospital that is seeking to employ nurses and serve patients and do everything they possibly could to make sure that happened. And that's where we come to one of Johnson's next offenses, inability or impossibility. You can't find somebody acted willful if it was impossible for them to fulfill those obligations, okay? Now, OHS can take this gilded tower view that says, until you get a con and until we allow you to terminate these services, you have to provide those services. Well, Johnson Memorial, for lack of a better term, triaged this. They transferred nurses and doctors to Trinity, to St. Francis Hospital. They got them trained. They got their patients there so that they were cared for. All of these constituent populations were taken care of. But Johnson Memorial it was impossible for them to staff the services at the hospital 24/7 with the skilled labor they needed to adequately resume labor and delivery. So again, it's not that they terminated, it's not that there were layoffs, it's not that there was some sort of cost cutting here. It was that they couldn't get the skilled staff into Johnson Memorial. That's where the defensive mistake does come in. Okay, Johnson Memorial had a good faith belief, and Mr. Lazarus references this in his testimony as well, that when the pandemic ended, the labor force and the labor market would come back and that people would return to work and things would return to normal. So Johnson Memorial had the mistaken belief that if they just kept trying to recruit, if they just kept trying to staff this service, they would eventually end up on the other side of this wave and they'd be able to fully staff and provide the service. Well, it turns out that the declining usage of the service, the staffing challenges and everything were a burden that they ultimately couldn't overcome. And they made a mistake thinking they could, but that is not willfully ignoring their obligations under the statute. Now, we also come to the fine itself. You as the hearing officer have the power to rescind, revoke, or reduce the fine. The statutes give all sorts of discretion to you, and quite frankly, they give discretion to OHS on the front end. OHS didn't have to impose $1,000 a day fine. Going to the default of the maximum fine in this situation, knowing everything OHS knows about the situation here, is an abuse of discretion. And to let that $1,000 a day sit, if you don't rescind the fine altogether, would be inequitable based on the situations and the circumstances Johnson Memorial Hospital was facing. We would submit that it's completely appropriate to revoke the fine completely, given the facts and circumstances here. As a threshold issue, the filing of the CON application itself, black letter law, is enough for OHS to rescind or revoke the fine. There's no question, and the record is clear, that Johnson Memorial Hospital eventually filed the CON. And again, the facts and circumstances giving rise to why we're even having this dispute here would call for, if the fine's not rescinded entirely, a drastically reduced fine. As I mentioned before, for 13 months, OHS was aware of the situation going on at Johnson Memorial. We don't know why, we don't have a witness who testified why OHS didn't file the penalty prior to June of 2022. We can speculate that maybe they were giving Johnson Memorial Hospital a chance to get their staffing up to speed. But regardless, saying Johnson Memorial didn't file it for 13 months and imposing the maximum penalty on them, when OHS was aware of it, and OHS could have filed that penalty at any point in that 13-month period. The record is clear. Johnson Memorial was transparent with them that those services were suspended and Johnson Memorial couldn't provide them. If OHS determined that that was a termination, OHS could have imposed the penalty at any point, and we would not be talking about the astronomical number that is in the June 29, 2022 letter. But I would also stress, given your inherent power to revoke or reduce the fine, that these facts and circumstances are completely appropriate for that. As I mentioned, Johnson Memorial had no layoffs. Johnson Memorial's doctor was at St. Francis Hospital. Johnson Memorial hired nurses to staff the service. Those nurses were fully trained and then took other opportunities that, unfortunately for Johnson Memorial, they thought were better than the opportunities at Johnson Memorial Hospital. Patient care didn't suffer. And that's one of the primary focuses of what Johnson Memorial was doing here. They were trying to get the service up and running until they realized it was absolutely impossible to do. And then they filed the CON application in June of 2022. And again, when we're looking at the timeline of what OHS could have done with regard to the penalty, we're not blaming OHS, just like we don't believe Johnson Memorial Hospital should be blamed. We're just pointing out that there were several milestones along the way here where both parties had opportunities. And I think it's inequitable to look at this and say, Johnson Memorial should have done something when OHS had the exact opportunity to do something as well, and they sat on their hands and did nothing. So in conclusion, I'd just like to say that Johnson Memorial Hospital here did everything in their power to resume labor and delivery services during this unprecedented time in healthcare and with the global pandemic. They were focused on providing fully staffed, safe, and competent services. They took every step they reasonably could to lift that suspension. They ensured patient care was a top priority. They ensured patients received the proper care. There's no evidence that any patients suffered for lack of services. Johnson Memorial recruited and trained potential labor and delivery staff who achieved those competencies that then went to work for other hospitals when that training was complete. Again, entirely beyond Johnson Memorial Hospital's control. If they had stayed with Johnson Memorial, we would be having a different discussion here today than the one we're having now. Ultimately, Johnson Memorial was faced with the reality that they were not going to be able to resume providing these services at the level they needed to in order to be in compliance and to provide good patient care, and they filed for the CON. Given the entirety of the facts and circumstances here, we submit to Your Honor that this is not a situation where Johnson Memorial Hospital should be punished or sanctioned. We ask that you take this entire record into account and you not impose the fine against Johnson Memorial Hospital in these circumstances. I'd like to thank Your Honor for your time today, and I'd like to thank Attorney Manzione for her professionalism and her courtesies in preparing for this hearing. I'd like to thank Mr. Lazarus for his testimony and his patience with our questioning and everything. And I'd like to thank my witness, Stuart Rosenberg, for the same, his patience and putting up with our questioning and making himself available today. And with that, unless Your Honor has any other open issues or any questions for me, that concludes my presentation.
Thank you, and thank you all for attending today. I do not have anything else that I need to address on the record. This has been very informative. So this hearing is hereby adjourned, but as I indicated earlier, the hearing record will remain open until after those legal briefs are filed. And that deadline will be determined at a later date, depending upon when the transcript is received. And also, as indicated earlier, the parties have stipulated to a pause of the potential period during which any additional civil penalty can accrue. So we will just set a date for those briefs as that allows as much time as the parties feel is necessary. So thank you very much, and this hearing is hereby adjourned.
Thank you.
Your Honor.
Thank you
Thank
all.
counsel.